Very good evening to all the learned participants, and good evening to today's resource person, Professor T. Ramakrishna sir. This is the 27th lecture in the Know Your IP online weekly lecture series organized by the DPIIT IPR-Chair, Osmania University. And today we are very fortunate to have with us one of the most eminent intellectual property law professors in India and even in other countries, Professor Thammaya Ramakrishna, DPIIT IPR Chair, Professor, Senior Professor from National Law School of India University, and who is a doyen in the field of IP education in India, is with us. Sir has graciously agreed to speak to us on the protection of industrial designs with reference to the United Kingdom and United States of America, probably India also. Professor T. Ramakrishna is Professor of Law, IPR Chair Professor. He obtained his B.Sc long time back, 1974, LL.B in 1977, LL.M with specialization in international law in 1979, all from Mysore University. Apart from that, he is also a postgraduate in political science and public administration from Karnataka University, and he obtained his Doctor of Philosophy degree in intellectual property rights in 2000 from Mysore University. And before joining the National Law School of India University, Sir worked as a lecturer, reader, and professor at Vidyavardhaka Law College, Mysore, and as its principal from 92 to 2002. And it is well known that his areas of specialization include intellectual property rights law, international law, criminal law, and law of evidence, conception of justice, and global legal order. And he was visiting faculty at the Department of PG Studies and Research in Law, Mysore University, and also Karnataka Police Academy, 1990 to 2002. Sir joined the prestigious National Law School of India University as professor in 2002, and at present he is the IPR Chair Professor of the Ministry of HRD at the National Law School. He is also the coordinator of CIPRA, that is the Center of Intellectual Property Rights Research and Advocacy at the National Law School, and also the head for the Institute of Excellence on Intellectual Property Rights and Standards. Sir is a member of several expert committees constituted by the Intellectual Property Office, the National Biodiversity Authority, the Protection of Plant Varieties and Farmers' Rights Authority, Copyright Office, and member of the Institutional Ethics Committees. And he was the chairman of PG Council, special invitee of the Executive Council, and member of the General Council of National Law School. Sir widely traveled across the world, visited the University of Sussex, UK in September-October 2004 under the DFID project, the World Trade Organization and World Intellectual Property Organization in Geneva, Switzerland during June-July 2005, and he participated in the colloquium on IPR. Sir also visited US in 2006 at the invitation of the US Department of Justice for studying the IPR enforcement models in US. He participated in the Indo-German colloquium on intellectual property at Freiburg, Germany during May 2008, and at the Conference of Parties COP of Convention on Biological Diversity at Bonn, Germany. He also participated in IPR workshop organized by the Ministry of Economy, Trade and Industry at Tokyo, Kyoto, and Osaka. In fact, the list goes on. Sir has participated in numerous prestigious academic and research-oriented programs across the world. Sir has been selected as a visiting professor of the Indian Studies Law under the ICCR Chair, Government of India, in the University of Colombo, and worked as chair professor between January and April 2012. In May 2012, Sir participated in the regional consultation and planning workshop on use of TRIPS Flexibilities to have access to affordable medicines in India, organized by UN Development Program, World Health Organization, and UNAIDS at Bangkok, Thailand. And Sir participated and presented papers in the High Technology Protection Summit organized by CASRIP, University of Washington, Seattle, USA. He submitted and presented a commissioned paper on IP and ICT standards in India at a conference organized by National Academy of Sciences USA in Washington, D.C., October 2012. And there are many more laurels which have been won by Professor T. Ramakrishna. And in fact, recently I was delighted to read in one of the websites that an award has been instituted in his name by Banana IP. In fact, one of the leading IP law firms in the country. I think steered by Dr. Kalyanti Kanakala, and that is the kind of adulation sir enjoys in the IP world. I don't want to stand between the eminent professor and the participants. Dear participants, you are hailing from different backgrounds, different professions, maybe academia, industry, or legal profession. But this is the best opportunity to make use of the vast experience and erudition of Professor T. Ramakrishna. Now, I wholeheartedly request Professor T. Ramakrishna sir to make his presentation on designs. Over to you, sir. Thank you.
Friends, of all the categories of intellectual property, perhaps the one area which needs entire technical background is the law of patents. Copyright is equally a challenging area. Geographical indication is the current topic on which the entire population in the country is interested. Almost every state has tried to identify the proper geographical indications, and then they're trying to register them and then give the actual protection for that. Even our center also was given that responsibility in Jharkhand to identify the GIs of that particular state and then register for that. And similarly, right, other IPRs as well. We also started recently a study on the trade secret, and in association with some other organization, we started drafting a legislation for protection of trade secrets in our country. So this is the background. Coming to the protection of industrial designs, see, something that is aesthetically appealing, something by which the entire market is loaded, something, the protection for which almost every seller, every businessman would aspire for, is the industrial designs area. We had, prior to the independence, the Patent and Designs Act 1911, and now after we signed TRIPS, we have the Designs Act of 2000. Just to give you a quick glance of what could get this protection. For example, the travel goods you have. You have the bag, you have a keychain, you have other materials which you're going to carry. And when you're carrying these, it's not just the functional feature that you're going to look into, but also the aesthetic feature that you're going to look into. That you're going to have a bag with a long handle, or with other features, or a key with in distinct form. Similarly, even the foodstuffs for that matter, right? You have a chocolate, but the chocolate that you eat are designed in such a way that it would attract the person who's going to eat. Would it change the sweetness? Would it change the taste? It might not, but it would appeal to the buyer, and the buyer would be able to get or purchase those things. So this is something that a buyer would go not for the functional thing, but for the aesthetic appeal that he's going to get. Similarly, see the locking devices here. All would serve the same function of locking a particular door, but the look and feel of them are not the same. Each one has a distinct feature, distinct configuration, distinct shape, and even the stringed musical instruments. The instruments that are there, which any one of us would use, they're also having distinct designs put on them. I have just mentioned few of them, friends, here. And having mentioned few of them, let me just quickly go through what a design means, how the design is defined. If you just look at the definition of registered design, in the Registered Designs Act, the design directive, and the community design rights, right, of the EU, European Union, you find that it is defined in this particular manner, which means it's the appearance. Appearance of the whole are a part of a product resulting from the features of, in particular, the lines, contours, colors, shape, texture, or materials of the product or its ornamentation. If you just look at the definition part, I'll become to the Indian definition part also in the short while. They're referring to the appearance, right? Appearance need not be the whole of the product. It could be even the part of the product. The whole product or the part of the product, which results from the features of the lines, contours, colors, shapes, texture, or materials of the product or its ornamentation. So now the question that comes up before us is, what is that product that we have been talking of? I'm going to elaborate this as I move forward. Product here is any industrial or handicraft item. It doesn't refer to the computer programmers. And in particular, it includes, the definition goes, a packaging, getup, graphic symbols, typographic typefaces, and parts intended to be assembled into a complex product. See the next part here. Parts that are going to be assembled into a complex product, which means when part of the complex product would also be entitled for a distinct design protection. So the appearance of this particular product would be entitled for this design protection. And by virtue of this, the overlap with copyright law and trademark law is tolerated to some extent. What is the definition that we have under the Designs Act? We have defined it to mean only the features of shape, see the 6 categories, shape, configuration, pattern, ornament, or composition of lines or colors applied to any article, and the article to which it's applied may be 2-dimensional or 3-dimensional or in both forms, and that application to the article should be by any industrial process or means, and that process could be either manual, mechanical, or chemical, either separate or combined. And the last element is that these features are going to appeal to and are judged only by the eye. To put them briefly here, the 4 features. Number 1, shape, configuration, pattern, ornament, composition of lines or colors. And by themselves would not be designs. They will have to be applied to an article, which means there must be an article in existence to which these are applied. And this may be whether 2-dimensional or 3-dimensional or in both forms. And such an application is made by any industrial process or means. And that industrial process could be either manual, mechanical, or chemical. And finally, appeals to or is judged by solely by the eye. Fine. However, there are also exclusions that have been mentioned here, to which I'll be adverting at a later stage. It says, number 1, any mode or principle of construction are excluded. Anything which is in substance a mere mechanical device is excluded. It does not include a trademark. It does not include a property mark. It also does not include an artistic work as defined in the Copyright Act 1957. Friends, what are the requirements which particular shape would become a design. What are the essential requirements to be satisfied by this design? Either it should be novel or original as specified in the Indian Design Act. And if you just look at the design law, essential requirements are that these shape, configuration, etc. must be either novel or original as contemplated in the Indian legislation. And if you go to the UK legislation, it also adds one more. It should be novel as well as have an individual character. These are the two elements. Let us just have a quick look at what is considered to be novel or what's considered to be original. Okay. Now we find the definition of original as we find in the Act itself. It says it is originating from the author of such design and includes the case which, though old in themselves, yet are new in their application. So new in their application. I am sure you would have gone through copyright law and originality and the copyright law, and that has a very rich jurisprudence. Especially if you look at copyright and originality and the copyright law, right? You can examine the position of BBC versus Vidyavardhaka in India, and then the phased case in US, and then the development that happened in other jurisdictions across the globe, which have adopted the new approach. I'm not getting into those issues related to copyright now. It must be original. This is the definition of originality, which indicates that it has not been published anywhere in the context of that particular article. It should not have been previously published in India or any other country. So not known. So publication, as we know, which we apply in the patent law also, it could be in the prior document or it could be by prior user, which is available already in the market. And if it did not exist earlier, you would have established novelty. Even when you file an application for designs, you will have to clearly indicate what is called as a declaration of novelty must be done. They should very clearly and specifically say that this particular shape, this particular configuration, this particular pattern is the novel feature over which I am claiming the design. And if it is originality, right, even if the design is old or the shape is old, but still if it is new in its application. For example, there are many designs that we have seen. Could be Qutub Minar, is just an example that I have taken here. And if you apply that to a pen and create a pen with Qutub Minar structure, it's original, it may not be novel. And to become original here, that design that you have applied must be distinct from the already existing one in the material details. There is a case, B. Chawla versus Wright Auto Industries, where there were merely addition of curves, some curves here and there in the rear view mirror. And the court says, yes, there are changes we find, but those are in immaterial details. And therefore, design itself is neither novel nor original, and therefore would not be entitled for the protection. Let me just quickly take you through something interesting. Novel and individual character. Right? Individual character is the one which I thought I would focus a little more and then explain you clearly. This is how it's defined. I just take you through that and then explain you. If the overall impression it produces on the informed user differs from the overall impression produced on such a user by any design which has been made available to the public before the relevant date. So if today is the priority date, if the design is made available to the public on that particular day, an informed user, I have been using the word informed user. This is what the law says. The informed user gets an impression, and that overall impression that he gets by looking at the claimed design is different from the overall impression that had produced on him from the existing designs. You see the two here. Existing designs have created an impression. The new design creates an impression, and the new design created impression is different from the other one, to whom you should be an informed user. So now the question that comes up often, who is that informed user? You have trademark law on the one hand, you have the patent law on the other hand. If you go to the trademark law, I am sure all of you would have heard about Amrutdhara Pharmacy versus Satyadev Gupta, which goes through the Calcutta High Court and then goes to the Supreme Court. The Calcutta High Court dissecting the two words, right? Amrutdhara and Lakshmandhara, taking us back to Lakshmana, taking us back to Amruta, and then saying that there is no confusion. It goes to the Supreme Court, and the Supreme Court says that a person who goes to the market and asks for a particular product would not stand there dissecting the words the way High Court judges have done. Amrutdhara, if someone asks Amrutdhara and the shopkeeper says I have Lakshmandhara, the question is whether that individual is likely to get confused or not. Who is that individual there? That individual is an average consumer. The Supreme Court said here very clearly that he is an unwary purchaser with average intelligence and imperfect recollection. That's the person. So on the one hand, we have this average consumer. On the other hand, when you go to the patent system, when you analyze the patentability, you have novelty determination, utility determination, non-obvious determination. Who is that person to whom it should be obvious? And you would say it should be to the person having ordinary skill in the art. Who is that person having ordinary skill in the art? If it is an invention relating to mechanical engineering, a mechanical engineer, a computer scientist if it's relating to that field, a microbiologist if it's relating to that particular field, which means a computer expert will not be considered as a sectoral expert with respect to microbiology. So sectoral expert on the one hand. Our informed user under the design system is someone who is not just an average consumer under the trademark law, nor a sectoral expert under the patent law. He stands somewhere in between that. The reason is he is informed about the availability of the design in the market, and then he forms an opinion, right? Not like a sectoral expert under the patent law. So that is the person, or for him, if it is distinct, then it becomes, it passes the test of individual character and would be entitled for design protection. And in such circumstances, Section 1B, Para 4, it speaks about the design freedom. It says, the degree of freedom of the author in creating the design shall be taken into consideration while determining individual character. Was he having that particular freedom? Or was he bound to fit in that particular design to a larger complex product or not? So that is going to determine the extent of individual character that particular design has. So these are the requirements for it in India and UK. Moving further, novelty in UK as defined in 1B, Para 1 and 2, it says, if the extent that the design is new, that's individual character. And for new, it says, if no identical design or no design whose features differ only in material details has been made available to the public before the relevant date. That's the novelty element. Moving further, there are at least 2-3 cases to which I'm going to take you to. One is Dyson, right? See here, the registered design is relating to cylinder vacuum cleaner. You can make out from the two pictures that I have shown here. One is giving a particular impression. What is that impression that one would give? You get a smooth, curving, elegant, thought about the first one. But the second one, if you look at, it gives an impression of being rugged, angular, and industrial. I'm sure you will be able to make out that from the picture that I am sharing that with you. And the court looks at this and says, if the informed user gets an overall impression which is different and distinct from the overall impression that he gets by looking at the existing design, then the new design would be having individual character. And if that is reproduced by others, it's likely to become infringement. On the other hand, if the product manufactured by the other person is also having an individual character, then that would not be a copy of the first one, nor an obvious imitation of the first one, and hence would not amount to infringement. That's as far as Dyson versus Wax Limited case is concerned. Let me take you through another case, Gardeco Limited versus La Hacienda Limited, in which similar issue came up. It was design relating to a conical steel chimney. It was a chimney. The chimney has stainless steel rim around the mouth. And the respondent here sought to invalidate this particular registered design. And he says that this is in violation of 1B1 of the Registered Design Act relating to the individual character. Let me just show you the two shapes here. This is the first one, Gardeco Limited's product, and the second one, La Hacienda product. This was compared, and finally the registrar says there were sufficient differences between the two. The sufficient differences here are producing a different overall impression on informed user, and therefore Gardeco design was novel, and invalidation cannot happen. So it was happened to be a valid one. This is just to highlight what we call the individual character. Novelty we have understood. The shape, configuration, etc. should be novel, original, or having individual character as highlighted in the UK legislation. It must be applied to an article. We have used the term article, and there you find the word product. What is that article that we have been talking of? It is an article of manufacture, and it also refers to a substance which is either artificial or partly artificial, partly natural, and includes any part of an article which is capable of being made and sold separately. If it's been made and sold separately, it would become an article for the purpose of design side, even if it is part of an article. Fine. Then the product, definition of product, as you can see here, it means any industrial or handicraft item. They're very, very clear. Industrial handicraft item other than a computer program, and includes all these. Packaging. Hope that part is clear to you. So one particular question that came before us in the previous slide was, how can parts of an article also get design protection, and how are you going to say that this part is entitled and this part is not entitled to? Fine. Registration of part of an article not specifically provided under the Indian. Expressly it's not provided, although it says part of an article is also included. The leading case on this particular one is the House of Lords, 1995 decision of the House of Lords, and these are the two questions that was there before the court, the House of Lords. Can there be design protection for wing mirrors, steering wheels, seats, etc. of a car? You have given protection to the car, right? Overall design protection is given. Can you give separate protection to the wing mirrors, steering wheels, seats, etc.? And also, can you give separate protection for the spare parts like door panels, bonnet, etc.? So now, if you just think over and look at how the court decided, I am sure you know which part of which article is entitled for design protection. The court says here, parts such as wing mirrors, wheels, seats, and the steering wheel, though they are contributing to the appearance of the vehicle, they are subsidiary to its essential shape. I am sure you will be able to make out. They are contributing, but they are not dominantly contributing. They can be made and sold separately, and hence they would be entitled for separate registration. The first one is clear. The second one, bonnet and the side frames, which form part of and contribute to the overall shape and appearance of the vehicle. So they are contributing to the entire article, entire product of the entire vehicle in this particular case. So such parts which contribute to the overall shape and appearance of the vehicle would not be entitled for registration. Separate registration meaning, as part of the car, as a car share it is registrable but not in this particular context. So what is the principle that emerges from here? That is, design must be applied to an article which has an independent life as an article of commerce, and which is not just an adjunct of some larger article, right, of which it forms a part. So part of an article is clear to you, I'm sure. Then the next one is it must have an IIP, right? So the whole focus of this design is that it must be appealing to the consumer. So if a consumer goes to the market, he will be buying a particular article not for its functional features. He buys that because it appeals to him. Between the two bags that I look at, one bag attracts me. Between the two phones that I see, one phone attracts me. Between the two refrigerators I see, one refrigerator attracts me. Between the two mirrors that I see, one mirror attracts me. And that is the artistic appearance. So that appeal to the customer is a test for determining it. The next question is, should that be wholly visible to the consumer when he buys it? At least there are two cases to which I'm going to take you. It said that features not fully visible at the time of purchase may also be entitled for design protection. The two cases here are, one is Suva Seikosha Designs application, where the design was relating to display panel for the digital watch. It was related to the configuration and pattern in the form of sound and bell symbols, and it was visible only when connected to circuitry. Otherwise, it's blank. Then, on appeal, the appellate court says, well, even if it is not fully visible at the time of purchase, still, when circuitry is connected, it will be visible and therefore would be entitled for design protection. Similarly, in Ferro versus CSPS application also, it was relating to chocolate egg, which had an inner layer of chocolate surrounded by an outer layer of dark chocolate. They say, after serious discussion, they said it's registrable. It is not visible at the point of sale, but the whole object of this particular product is that it should be broken and then looked at. At that time, it will be visible and therefore it's entitled for the protection. It was Judge Whitford who was saying, as it was inevitable that the egg would be broken open, and therefore the pattern would be seen, still IIP would be there. Where the features claimed were features of the finished article, the features need not be judged at the time when the article was bought. This is the test in the two cases that I have shown you here. Then there are certain designs which cannot be registered. Quick look at it, and then as I move forward, I'm sure I'm going to explain you with the case laws many more issues that come up. If it's a mechanical device, it would not get protection. If it's a trademark, if the definition says it will not get protection. If it's a property mark under IPC, it will not get protection. If it is an artistic work by itself, which is not registered here, will be entitled for copyright protection, but not a design protection. Then, if it is no new or original, it would not. If it is disclosed already, it will not be entitled to. And if it is different from the known design, it will not be entitled to. And lastly, scandalous and obscene, or even if it is contrary to public order or morality. Friends, this public order or morality exclusion you find in almost all the legislation except copyright. Right? Then in UK, Registered Designs Act. What are those that are excluded? I'm only referring to Registered Designs Act. First one is, if it is solely dictated by the product's technical function, a leading case on trademark law, Phillips versus Remington principles have been applied in this case. Phillips had a Phillips shave which had a equilateral triangle in which there were 3 circular rings for the purpose of shaving, and that was deciding the technical function of that particular shave. And it goes to ECJ also. ECJ also clearly indicated and said that that is functional nature, would not be entitled for trademark protection. So if it is functional, similarly here, design also will not entail for protection. As we move forward, many more cases on functionality will be taken. And the next one is interesting. A right in a registered design shall not subsist in a design which is contrary to public policy or to accepted principles of morality, the same thing that you find in our legislation as well. This is an interesting point, friends. Please note this when I come to unregistered design, I'm going to explain you the case law. A right of registered design shall not subsist, where in features of appearance of a product, which must necessarily be reproduced in their exact formal dimension, so as to permit the product in which the design is incorporated, or, or that which it is applied to be mechanically connected or placed in around or against another product, so that either product may perform its function. So you have a particular design that you have applied. I'm just taking a very simple thing here. And this particular shape is necessary for fixing it to another article or another product. What happens when it is manufactured in that particular very shape itself, which fits into the other one? Either the other article starts functioning or this article starts functioning. In such case, it is called as must fit. Must fit is an exclusion both under registered designs as well as unregistered designs act. These are the two examples that I would like to give here. One is opposed to morality, where it was a case of design for a male Highlander doll. The sporan was lifted, it is revealing the genitals. Aldous J says, the test was not whether a section of the public would be offended. Instead, the test was whether the moral principles of right-thinking members of the public would think it very wrong for the law to grant protection for that. And therefore, on the basis of morality, we are going to exclude that. Similarly, if it is dominant or functional, for example, in the case of Smithline Beecham of Hindustan livers, it was related to the toothbrush, which had that S-shaped folds, right? And on the one hand, you had the bristles, on the other hand, you had the handle. Whether this S shape here is aesthetic in appeal, and so yes, it's aesthetic in appeal. Is it also functional? The court says yes. And therefore, as you can see in the last one, the dominant purpose of the feature is functional and utilitarian, and hence would not be entitled for design protection. Hope that point is clear. Well, friends, very, very brief overview of how do you get registration for this. Application you're going to file, Section 5 provides for that. Form 1 facilitates you, and there's a prescribed fees of either 1,000 or 4,000 rupees to be paid. And you have to clearly indicate the class under which you are going to file this, because the classes have indicated clearly the articles. Class 1 to 31 is there, and then 99 is also there. So totally 32 classes are there, and your article may fall under any one of these things. You're going to mention the article, provide a representation, and there must be a statement of novelty. If you have filed an application in your name, it can be substituted because you're going to assign the rights to some other person, or there may be an agreement with some other person, or I may not be surviving and my representative may take over. So there is provision for substitution of the application under Section 8, Rule 16, and Form 2. Once application is filed, there will be objections raised, and there will be given opportunity for responding to that. In the absence of that, it's deemed to be abandoned. Right? Then there will be acceptance. If I have responded to all of them, there will be acceptance, and if it's accepted, there will be issue of registration certificate, the Section 9. Then it goes for publication. Once it is accepted and registered, published, I will be entitled for design protection for 10 years, and after 10 years, I can extend it by another 5 years. By any chance, if I have not extended, then it might lapse, but I still have a 1 year period for restoration of the lapsed design. What's the remedy that's available to me? Once it is registered, then other persons interested may have option of cancellation of that. Right? The cancellation could be on any one of these reasons, but that must be done only by a person interested. It could be on the ground of previous registration, it could be on the ground of previous publication, it could be on the ground of not being new or original, not registered under the Act, and not a design under the Act. For any of these reasons, it can be cancelled. Hence, this is the flow chart. I need not go take you through the flow chart. And similarly, if you just look at UK position, Applications in the prescribed forms will have to be filed, and the normal practice there is that they shall not refuse except under certain circumstances. Right? Normally, the rule is that they register it. Like if the rules are not compliant, if the person is not entitled to apply, and the requirement of design or novelty, etc., is not fulfilled, or if it is functional or contrary to public policy or morality, it's not going to be registered. So registration will be as on the date of the application itself. Same position followed everywhere. And once it is registered, the registered person is going to get exclusive right to use the design. Grounds for invalidity are also provided here. And the rights of the proprietor, the Indian law is very clear. He gets what is called a copyright in design. Note carefully here, the word copyright is defined in section 2C of the Designs Act. Don't go back to section 14 of the Copyright Act. Copyright is defined as an exclusive right to apply a design to any article in any class in which the design is registered. If you have registered the design under a particular class, then you will be entitled to exclusive use of that particular design on that particular article coming under that particular class. That's the copyright in the design that this act refers to. Can you assign? Yeah. License? Yes. Mortgage? Yes. Transmission can happen? Yes. All this can happen, but all this must happen in writing and writing only. Then these are all the, this is what section 430 refers to, about the transfer of rights. When does infringement happen? I'll be taking you through case laws also. When does infringement happen? Right, this part I'm sure should not pose any problem at this particular stage. What amounts to infringement? What does not amount to infringement is also provided here. For example, if it is done privately and for purposes which are not commercial, purely for experimental purposes, purely for teaching purposes, use of equipment on ships or aircraft. Right? Similarly, the right of prior use also is recognized. And in India, we have this provision which says, 22 says, if any person applies the design on a similar article, or if there is a fraudulent or obvious imitation of the design without consent, then it is infringement or piracy. Or if it's already applied and then that those articles are imported for sale in India, it is violation. Then, if someone publishes or exposes or causes to be published or exposed for sale, that specific article with the knowledge that is applied amounts to piracy. Decision on infringement decided in various cases. I have just summarized by picking up what the court stated in Castrol India versus Tide Water Oil. What does it say? When you say imitation should be there, does it mean duplication? Does it mean exact copy, exact replica? Not required. For you, it appears to be an imitation. That's enough. It need not be exact copy. Then the court further said, we'll have to see in particular as to whether the essential part of the basis, the plaintiff's claim for novelty forms part of the infringing copy or not. I have claimed novelty in pattern. Has that been copied there or not? Similarly, similarity or difference must be judged through the eye alone and not by the functional purpose. Court must address its mind as to whether the design adopted by the dependent is substantially different from the design which is registered. And finally, going to the three elements that I mentioned, obvious imitation or fraudulent imitation. It says obvious means something which as soon as one looks at it, strikes one as being so like the original design, as being almost unmistakable. Fraudulent imitation is an imitation which is based upon and deliberately based upon the registered design and is an imitation which may be less apparent than obvious imitation. So you have seen that and then you are trying to cover up and want to project as if it's a different part. Still it could be an imitation. So both obvious imitation as well as fraudulent imitation would be amounting to infringement. Right? And the latest one, just a month back, I would suggest all those who are listening to me to go through this particular case in particular and also commentaries on this particular case to a large extent. This was the two that were compared. Plaintiff's fans were called as enticer, art, NS Stone, this is how it looked at. Venice Prime of Manasoni, these two were compared, and the court has elaborately debated and discussed almost all the issues relating to the design's interface with trademark, design's case with passing off, design and copyright, all of them the court has discussed. Those issues I'm going to take up in a short way. And in this particular case, the court said, we are satisfied that defendant number one had several other options and alternatives to adopt another design without applying a design which is substantially similar to that of the design of 2020, that is 2020 heavens. And hence, it says that that we come to the conclusion that there has been copying, cosmetic differences, and a node inquiry is uncalled in this particular case. And hence, it was held to be infringement. Well, friends, I have just few issues which I'm going to pick up and then take the next few minutes to highlight that so that that can be debated. Protection of registered and unregistered design. Is there protection for unregistered design also in India or in UK? And that's the crux of my talk today. One particular case, let me just take you through. Kohler Mira Limited versus Dristan Group Limited, 2013 case, in which the allegation was that several design features have been violated by the respondent. Of that, few were registered shape and configuration, whereas few were unregistered design also. See, as you can see here, Mira relied with respect to the unregistered design rights relates to shape and configuration on the following aspects of shape and configuration in its designs, both individually and collectively. So, both registered as well as unregistered designs were an issue, and that was taken up. Will someone be entitled for that? The court went ahead and then said, yes, there is infringement of both, which means even unregistered design protection is also guaranteed in a suit in which registered design protection was sought. Come to Indian position. In India, we have a very peculiar provision under Copyright Act called as 15, section 15, 15.1 and 2. If you look at 15.1 and 2, it says, copyright shall not subsist if any design is registered in the design act. So the definition, it is excluded. Sometimes you may apply an artistic work to an article, and the article is reproduced for more than 50 times. Until you reproduce for 50 times, you will be eligible for copyright in design. But after 50th product is done, you are not entitled for copyright in design unless you have registered that particular design, which means an unregistered design would not be entitled for protection under the Design Act. That is the rule. Let us just go through other cases. How is unregistered design right protected in UK? We have CDPA 1988 Part 3, which expressly defines as to what a design is. It simply says, design is any aspect of the shape or configuration of the whole or part of an article. It refers to, see here, shape or configuration, whole or part of any article. So any aspect of the shape or configuration of the whole or part of any article. And when does design right come into existence? There are two ways. One is the person should have recorded in a design document. Design document could be a record of a design, right? Either drawing, written description, photograph, or data stored in the computer program, etc., which you have notified. So you have created design document and therefore are entitled for the protection. Or second provision is an article has been made to that particular design. In both the cases, even if you do not go for registration, you will be entitled for registered design and registered design protection. And friends, under the unregistered design rights, there are several exclusions which as I told you, will be the focus of my discussion today evening. First exclusion, section 213(3)(c), it says surface decoration cannot be claimed as a design under the unregistered design rights. And the example itself is very, very clear to you. See the two. It's a kitchen cabinet. In the kitchen cabinet, the code says paint and finish, V grooves, cork beadings, they all, these three, if you just look at paint and finish, etc., they are surface decoration that are being made. So surface decoration should be excluded. On the contrary, in the kitchen, cornice that you have made, the quadrant corners that you have made, or the panels that you have made, they are part of the design. It's not just a decoration, surface decoration that you have made, and therefore would be entitled for design protection. Similarly, in A. Fulton versus Grant Barnett, they said the stitched beams of umbrella, stitched beams of umbrella are significant aspects of shape and configuration, therefore would be entitled for protection. On the contrary, the process or operation by which shape is produced, those stitched beams are produced by themselves will not be entitled for any design protection. That's the second one, exception, methods or principles of construction. And this is the most interesting, friends. I've already referred to this. The simplest example that we can think of is take the mobile phone case. Is the shape of mobile phone case entitled for design protection? It will not be, because whatever phone you have, it perfectly fits into that, including your buttons that on either side and the charger point on this particular side. So it exactly fits in. So makes this particular one functional the moment it is put in, and therefore would not be entitled for design protection. Similarly, the handle of a vacuum cleaner, it should fit into your hand, right? And therefore they would fall under must fit. And a very interesting case that came before the court in UK was the Ocular Sciences case of 1997, where they were claiming the design, the shape of the contact lenses, and that shape was the one which fit against the eyeballs. And when that shape fits against the eyeballs, it starts performing the function of correcting the vision. Can you claim design protection over that? You can't claim design protection over that, because must fit exclusion applies, right? So there was a controversy whether it can be applied to living things or non-living things, but this particular case set all of them right and said it can apply even to living things also. Of course, there was another case which came up, Amina versus True Life, where the court said must fit, you must apply it in such a manner as a rigid plug and socket. If that is the kind of must fit design that's being developed, only then must fit exclusion applies, otherwise it will not apply. Similarly, the must match is the aesthetic counterpart of must fit exclusion. I have already given you Ford Motor Company design applications, where the part which is giving or contributing substantially to the shape of the article itself would get excluded. So that's a must match one. Without that, without the bonnet, your car would not have a shape. Without the side frames, it will not have a shape. So the overall shape here is supported by the bonnet and the side one, and therefore they are must match. They also get excluded. And the last one, friends, is something which is in the common place. Something that's in the common place, right? C and H engineering is a case which has explained as to what would be something that's in common place, like work of a creator, and it must be result in a design which is not commonplace in the field. And there is a large, right, explanation and the jurisprudence developed in that field. In the Indian context, I was referring to the overlap. Section 15, 1 and 2 I have referred to, friends, already. And the leading case on that is the microfibers versus Giridhar and company, where the court said, this is the important part of the judgment, if the design is registered under Designs Act, the design would lose its copyright protection under the Copyright Act if it is a design registrable under the Designs Act but has not been so registered. The design would continue to enjoy copyright protection under the Act so long as the threshold limit of its application on article by an industrial process for more than 50 times is reached. But once that limit is crossed, it would lose its copyright protection under the Copyright Act. Right? This is the only way that we can harmonize between copyright law and design law, keeping in mind the legislative intent is what the court stated. Fine? That's microfibers case. And then subsequent Holland Company versus FP Industries also reiterated that and said that section 15(2) is applied, and therefore there is loss of copyright and design protection once you do not go in for registration. Although J.C. Bamford Excavators case went to the extent of saying that merely because parts of the product here have been manufactured by an industrial process more than 50 times, it would not necessarily lead to the conclusion that the copyright in the technical drawings of the said parts has ceased completely. Now, of course, section 52(1)(w) of the Copyright Act has created an exception in that particular field. Next question, friends, there are only two questions that I'm going to address now quickly. One is, we have design rights, right? And design period expires. Our design is not granted. Can I continue that as a trademark because consumers have started recognizing that particular design on my product consistently? Can I now use it as a trademark and then file a suit for passing off by another person? In Mohanlal versus Sona Paint Hardware, Justice Manmohan Singh was deciding this, and he says that it cannot be the case that on one hand the shape of the article is passed into public domain for free use by operation of design, and on the other hand the same very shape is again taken away from the public and put into bracket of the protection of granting monopoly rights in perpetuity by operation of another law, which is prior law, and thereby in effect the public is debarred from using the said shape of the article. See, the intellectual property rights, as we have understood, as an inbuilt sunset is what we have understood. After 20 years, patent period expires, something like that. So now, Justice Manmohan Singh says, this design right after 15 years lapses. What does lapse mean? It means that anyone in the public can make use of that. But now you are regaining that under this different law, the trademark law, right? And therefore it is a burden on the public. So that cannot happen is what Justice Manmohan Singh said. But that is not the law. It has been interpreted by different courts. In the dart industries, Vijay Kumar Bansa and others, Rajesh Sahai and also address the same thing. He says, no action for passing off would lie with respect to what was registered as a design. By seeking registration thereof as a design, you are deemed to have surrendered, abandoned, acquiesced, and waived all rights to use such features as a trademark. You had two routes to go. You opted for design. You can't go in for trademark again. So you have lost that particular opportunity, and that's what Rajiv Sahai Indla Justice said in that industry's case. Then the latest 2020 Super Smelters Limited versus SR MBS Region Private Limited, where the question was relating to use of X mark on the bar, which was considered to be double Y. Double Y was considered to be similar to XX here. And then XX was sought registration, which was refused on different grounds. Now the question, can they go in for suit for passing off or not, was the question. Let me just go through here. Justice here, Judge of the Calcutta High Court, examined Justice Manmohan Singh's interpretation and addresses that in this way. He says, the fear enunciated by Manmohan Singh that designs will not go to the public domain as they ought to post expiry of design registration if they are recognized as trademarks may be addressed by simply pointing out that such monopolization is restricted by standards required to be satisfied for recognition of the trademark itself. We have standards for trademark. That itself is going to restrict the scope. Are you protecting that as a design, or are you protecting that as a trademark and only for trademark purposes? then that is going to put the limitations and restrictions on the use of that particular right. And the judge here draws support from the INRE Morgan David Wine Corporation of the USA. USA, where they were trying to compare it with the design patent and the trademark. See how the court shows. They exist independently of it under different law and for different reasons. Termination of either has no legal effect on the continuance of the other. When the patent monopoly ends, when patent they said, this one, design patent. When the patent monopoly ends, it ends. The trademark right do not extend to it. We know of no provision of patent law, statute or otherwise, that guarantees to anyone an absolute right to copy the subject matter of any expired patent. Patent expiration is nothing more than the cessation of patent is right to exclude held under the patent law. So under that law, it goes off. But trademark law, it can continue. So super smelters, right, try to avoid Manmohan Singh's use and then come out with this INRE Morgan David Wine Corporation judgment. Supported that. And therefore, the court said, a mark can, this is what was stated in the super smelters case, a mark can, without being original or outside the public domain, in the context of designs, develop distinctiveness as a signifier of the proprietor's product. To refuse to recognize that said trademark has become monopolized by the proprietor as a trademark merely because the mark is also a design that has been cancelled due to prior publication would offend the very purpose of trademark law and do nothing to extend the purpose of designs law. The last, friends, the last point that I would like to discuss is this one. This is a very controversial, especially for practitioners. These three cases would be very, very much alive. Can you, right, file a composite suit invoking Order 2, Rule 3 of the CPC, combining designs infringement and passing of action together? On this, there are several series of judgments that have come. I would suggest you to go through all of them. First was 3-judge bench, which said, since there are a separate cause of action, they can be filed, they will have to be filed separately, but nothing prevents the judge from examining the merits of these two cases, clubbing them together while hearing the parties. That's going to reduce multiplicity of proceedings, right? However, Carlsberg Brewery is a case referred to the 5-judge bench, that where they said, I just highlight the point where the court said one composite suit can be filed by the plaintiff against one defendant by joining two causes of action, one for infringement of registered design of the plaintiff and the second of the defendant passing off its goods as that of the plaintiff on account of the groups of defendant being fraudulent or abuse imitation. So which means para 19 of the judgment here, it says composite suit for design infringement and passing off action is possible. And then if it has been further reiterated in Mrs. Kroc, INC USA, right, versus Mrs. Bata and others, where the court made this comment and said it was not appropriate that passing off suits and shape mark infringement claims were segregated by the trial judge. It should be thought not to have been done, especially in the light of the case Carlsberg decision. And that, friends, is just a quick overview of some of the issues that I thought I should be sharing with you this particular evening. And let me once again thank the organizers, thank Mr. G.B. Reddy in particular, wonderful person.
Thank you so much, sir. So that was a wonderful and lucid presentation on law relating to protection of designs, and replete with so many decided cases and leading cases. Thank you so much, and it makes a lot of difference, sir. It added more credibility to our humble endeavor for spreading more IPR awareness. Thank you so much. And now I will request my colleague, Mr. Srinivas Rao, to propose a formal vote of thanks. Over to you, sir.
Thank you, sir. Uh, Thank you, Professor Sir, for gracing this evening. And first of all, I would like to thank you for acknowledging our work at IPR Chair, Osmania University, Hyderabad, India. I can say that this presentation was a lucid presentation, and by collating various examples, case studies, and then developing the content in appropriate way that everyone can relate and understand the substance. You have nicely explained the concepts like novelty, product, industrial, and taken us through various benchmark cases, such as B. Chawla versus Bright Auto Industries, Dyson Limited versus Wax Limited, Radico Limited versus Hakinda Limited, Castrol India versus Tide Oil, and many more. Then you talked about the designs which can and which cannot be protected, and then you differentiated with those with the UK legislation. You have also clearly mentioned that how to make an application for designs and register the design, which you clearly elaborated with the life cycle of the design registration. You talked about copyright and design in tune to the rights of the proprietor of a registered design. In continuation, you mentioned what is amounting to infringement of rights and what is not. Also, you fine-tuned the relation in between copyrights, trademarks, and design registrations. Then finally, you mentioned how to protect the designs which are not registered. Also, you have given nice explanations to the queries raised by our viewers, sir. For that entire discourse, I would like to sincerely thank you on behalf of IPR Chair and the entire team of organizers of this event. We also thank all the participants and my team of organizers for their continuous and never-ending support. With that note, sir, we hope to see you all once again. And now we would like to conclude this session with the consent of the chair. Thank you, sir. Thank you.
Thank you, sir. Thank you very much.